Good morning. Welcome to the Charles Stewart Mott Community College special meeting of December 2nd, 2024. The time is 10 a.m. and call the meeting to order. Adoption of the agenda. Do we have a motion to adopt the agenda?
So moved.
Second.
So moved. Do we have a second? Second. All those in favor signify by saying aye.
Chair, do we have discussion?
Sure. If you'd like to say something. Trustee Freeman.
Yes. I believe that item 2.60, does that meet the requirements for a special meeting? Is this an emergency issue? Is my first question that has to be resolved during a special meeting. Second item, I object to as well due to complaints that have been received that need to be investigated. That I believe that this should be put on hold until such time as we've actually had an investigation of these complaints.
Thank you very much. Any other discussion? Seeing none, all those in favor of adopting the agenda signify by saying aye.
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 Those
Roll call
opposed,
vote,
nay.
please. Could we do roll call vote?
Sure, roll call vote. Trustee Reyes.
No.
Trustee Freeman.
No.
Trustee Couch.
Yes.
Trustee Daly.
No.
Trustee Walcott.
Yes.
Trustee Swanson.
Yes.
Trustee Everman is yes. The meeting agenda has been adopted. Do we have any communications from the public? Do you have any communications?
Mr. Chair, I believe you mean communications for the board?
Do we have any communications? This isn't the comments from the public, communications.
There's no communications.
Okay. Do we have any comments from the public, and only those related to the reason for the special meeting? Board Policy 1640 permits the number of comments to be limited. The board may limit the number of persons wishing to address the board on the same subject to 3. The length of time any one person may speak is 5 minutes. Remember, only the 2 items that are on the agenda today. Do we have any comments?
Yes, Mr. Chair, the first comment has been submitted by Percy Whitmer of Flint, Michigan, on the topic Future of Mott Community College.
That comment can be made at a regular meeting. The future of Mott Community College is not on the agenda today. There are 2 items on the agenda. Authorization for the interim president for the call agreement and the retention of counsel. That does not fit the criteria. The title of what you want, the future of the college, that's not what we're discussing today, but thank you very much.
Nope.
Next comment.
No, let him speak.
Is there a motion on the floor to let him speak?
So moved.
We
Support.
have a motion. Do we have a second?
Second.
And we have a second. I will ask the parliamentarian, can this be added? Given that this does not fit policy 1640, that permits only discussion on the items that are on the agenda.
Point of order.
Please state your point of order.
I dispute the chair's ruling on the fact that this is not inclusive. We are dealing with a resolution that would take us out multiple years, and that, by definition, includes the future of the college.
Policy 1640.
Your policy indicates that comments should be directed to the issues to be addressed in the meeting. The description he gave is rather vague. I don't know, without further detail, how to answer the question with respect to whether or not it meets the definite. If he's going to talk about the bonding issue, That would obviously could affect the future of the college, so I guess that would be considered into that. If we're going to talk about the hiring of a lawyer to draft a contract, that could also be considered, those things. If his definition of future of the college fits within those two criteria, then he should be allowed to speak.
Point of information.
Point of information.
It appears
Trustee
that-
Freeman,
it
I am now
appears-
recognizing
It
you.
appears that that's a title of what is being said. Does any of your comment, is it related to the
Please
employment?
direct your comments
Is
to
it
the
any,
chair.
is there any intention to address the employment contract? There we are.
Jordan,
So it appears that it is in
do you have
compliance.
this document?
It is in compliance.
Does it address the employment contract?
That's not for me to determine. I just read the comments.
So we don't have it on there. So we have a motion on the floor to allow him to speak. Roll call vote.
Point of order. The person just said it is about that. You're taking the title of what he said.
There's a motion on the floor, Mr.
Well, no,
Freeman.
I know, but
You're
the thing
out
is,
of order,
no,
Mr. Freeman.
actually,
There is a
there's no
motion
need
on
for a
the floor.
motion. There's no need for a motion at this point because the person clarified that they were actually talking about what's on the agenda. And if you don't allow him to speak, that's a violation of his First Amendment right and his ability to participate in public comment, which legally he is able to do. And if you deny him this, then he will have a suit with the
That's not a
with
point
the
of order,
college.
Mr. Freeman. That is simply a statement. Therefore, we
Point
give
of
back the
information.
motion that was
Point
on
of
the floor.
information. Can we
Point of order?
Point of order is recognized if you have a point of order.
Point of order?
Point of order, Mr. Daly.
The chair has not dealt with my original point of order yet.
Okay, we have a motion on the floor. Did
Point
you
of order-
rescind your
Point of
second?
order supersedes the motion.
Did you rescind your second?
There's no second on a point of order.
We have a motion on the floor. The point of orders have been addressed. We've now moved back to the motion.
No. The point of order, you are
Do you have a
cease
point of order,
business.
Mr.
I
Daly?
did. I've named it. And I want you to deal with it. I named it at the very beginning of this conversation, and you could blithely ignored it again.
Any other point of orders? Seeing none, we have a roll call vote.
Point of order.
Point of order from Mr. Freeman.
You are actually ignoring parliamentary rules at this point.
Do you
The
have a
issue-
point of order?
The issue has not been addressed. The first one has not been addressed. So until you address that, you cannot move forward with your motion.
It's not my motion. Okay,
Excuse me, Mr. Chair, for purposes of the minutes, could you restate your original point of order? I just got half of it.
My original point of order was that that the request to speak should be granted.
So that's the point of order. I did not hear the chair's ruling on that.
the ruling was until we heard whether or not policy 1640 was applicable to this. And given 1640, that permits comments only on the two items that are on the agenda today.
Mr. Chair,
You cannot just stop a point of order like that I'm entitled to a vote.
can you read the thing yourself really quick? He said that it's part of it. Let's just do a roll call vote.
Are we ready for a roll call vote on this?
On what? You seem to be
I'd
confused, so I
allow-
want to be
there
clear
was a
about what we're
motion.
voting on.
Trustee Daly,
What?
there was a motion on the floor that you seconded.
No. There is you have to deal, by parliamentary rules, you have to deal with my point of order first.
Okay.
All business
Attorney,
stops
would you
until a
please
point of
direct
order is
your attention
resolved.
to Trustee Daly and answer his point of order for him?
You have to answer.
The point of order was 1640, whether or not he can speak to the issue.
1640 indicates regular and special meetings of the board are open to the public. Citizens may address the board on those matters within its jurisdiction. Communications from the public shall come under the communications or comments. So the point of order was that you should allow this person to speak. That was his request. I have provided you with the policy provisions related to this. In your policy with respect to special meetings, it does indicate that the special meetings shall be limited, the comments shall be limited to those matters which are on the agenda. So we've had that discussion. So now it's up to you, given his explanation, as to decide whether or not you want to let him vote or not. If you do not want to let him vote, then it would be the vote of the board to decide whether that would take place.
My decision is to allow the board to vote and decide what they would like to do. Roll call vote.
Mr.
Trustee
Chair, point of
Reyes.
order. Do it again till you get it.
Trustee Freeman,
Point of order, Mr. Chair.
point of order.
I dispute the chair's ruling.
My ruling was to allow the board to
I
decide.
dispute the chair's ruling, and I am entitled to a vote by this body.
I am allowing you to vote on it,
No, on, point of order.
on your point of order.
Yes, sir.
Would you please state that again?
Trustee Daley raised a point of order as to whether the comments by Piercy Whitmer should be allowed to go forward as being in order under the policy that was stated. The chair ruled that it needs to be in compliance, but the chair has also ruled that he wants to have that ruling be made by the board, which means a roll call vote is appropriate on his ruling to allow the board to make the decision.
Point of order.
Trustee Reyes.
What has to happen is you have avoided making a direct ruling, but by what you've indicated, your ruling was against the point of order. He's challenged the chair, in which case there's a vote of the board whether or not to sustain your denial or whether to accept his point of order. Then, if we accept his point of order, then the person from the public gets to comment. If not, then a vote would then be held separately to allow the individual to vote. That's the way that this should be handled.
Okay, so what we'll do, it's been challenged. If you agree with the chair, it's a yes vote that you will get to vote on whether or not this person speaks. If it's a no vote, then Trustee Daley is right. Roll call vote. Trustee Reyes.
No.
Trustee Freeman.
No.
Trustee Couch.
Yes.
Trustee Daley.
No.
Trustee Walcott.
No.
Trustee Swanson.
No.
And Trustee Everman is a yes. The noes have it. So now, Diane, is this my ruling?
As you stated it, the ruling was to permit the vote to go forward on the separate issue of whether Mr. Whitmore can speak or not. So there were 5 noes and 2 yeses, so the vote cannot go forward.
So the vote
As you
cannot go
stated it.
forward, and it's my decision.
As you stated it.
No.
But I believe you meant to state it the other way around, that it
Bill?
is appropriate for a chair to allow the board to make a ruling. So the chair does not need to rule. The chair is able to say, I am going to allow the board to make the ruling, and I thought that's where you were going.
Bill?
Correct me if I'm wrong, Diane, but I thought he indicated in his motion that voting no would mean the gentleman would be allowed to speak.
That's correct.
Okay. So, given the title of this Future of Mott Community College, we will let the individual, Percy Whitmer, speak. Please pass that.
Good morning, Board.
Morning.
Pertaining to the contract that has been provided pertaining to my first comment, which was future of the board, it's quite disappointing that a alum of the college should have to wait 15, 20 minutes to be able to speak. Just shows where your hearts are. As far as anything else, I believe that we should be making the proper decisions as far as selection, as far as choices when it pertains to the future of the college, when we're talking about what contracts we will move forward with. I have had the privilege, not necessarily to be present in these board meetings, but I have been present virtually. And I have seen necessarily what has been moving forward and what has been taking place. And I wanted to make sure that my voice was heard when it came to what's about to happen for the future of my community college. I necessarily take this opportunity, if I was not to choose to speak, that my voice may have a little power, that my decisions have impact. So pertaining to the rest of my comments, I just necessarily just say, what are we doing? I am a very passionate person towards this cause of the future of Mott and where we will be going moving forward. Had the beautiful support of my community college at this time and moving forward. And I just want to take this time to just say thank you for that. And moving forward, please, please, please make the right decision for my community college. And also, this will not be the last time you all will see me. We will be moving forward, and we will make sure that the right individuals are in place for when January does come. Thank you.
Thank you very much. Are there any other comments this morning?
Yes, Mr. Chair. Just point of information, though, how would you like me to move forward then for each comment, given the vote by the board and each topic that's been submitted could, I guess, bring up future debates? So how would you want me to go about that?
Each item is supposed to be about the items that are on the agenda. There's 2 items on the agenda.
Understood. And I only asked the question, given that the topic from the
Given
first
that
comment.
comment, it didn't deal with the 2 items on
Okay.
the agenda.
All right, so the next comment's been submitted by Lisa Novak, MCC, on the topic of president selection process.
Selection process is not on the agenda today.
All right, next comment is submitted by Kathy.
Point of order. So you are discriminately looking at the language, assuming that it has nothing to do with, you're taking one sentence or a title, and then you're basically saying, judging whether or not, even before you know whether or not the person's going to be talking about this specifically. If the person comes up and nothing they say is about the topic, then you can cut it off and say, if this is not about what's currently on the agenda, you know, that we have to cut this off. But you're basically now looking at a title of what was written and not even verifying the fact that it's about the business of this. So you're canceling people before they've even had the opportunity to say, yes, I am talking. Why don't you ask them, if the title is ambiguous to you, why don't you look at the person and say, is anything that you're going to say relevant to what's on the agenda? That would be the best way to handle this moving forward.
Thank you very much, Mr. Freeman. The title was pretty straightforward. It was not ambiguous at all. She said the search process.
Mr. Chair,
Therefore, we have 2 items on the
Mr.
agenda.
Chair, until you
Item
verify this
260
information,
and 261.
you could be
Excuse me, Mr.
liable.
Freeman.
You could
The
be
chair is
liable.
speaking.
I'm just putting this out there that you actually are now, if you're canceling people before they have the opportunity to say, yes, I am talking about this. So like maybe we should have a box on the form that says, are you talking about what's on the agenda? Because right now, you've just tried to cancel the first person who was talking about that. And even if it's somewhat related to the agenda item, they still meet the requirement. So basically, I don't think it's a good look about you actually deciding who speaks and who doesn't during a public comment from taxpayers who support this college.
This is a board meeting. There's no cheering. There's no clapping. And if there is, there's an officer in the back of the room that will be happy to escort you out.
I think that requires a board vote. You can't do it yourself.
No, it doesn't, Mr. Freeman.
All right, well, you know what? Why don't you ask her, board chair?
So, let's have the last one that I just said couldn't speak. Bring her down, and if she gets off topic, we will then have to ask her to stop. Point of order, Mr. Daly.
I just had a question. You used the term "we," and I asked, is that the imperial we, or who is we? You said we.
You need to have your microphone on so you can be heard, sir.
Thank you. You said that we would stop her. I said, my question is, who is we? Is it the imperial we? Is it we, the board? Who is we?
It's the chair of the board, Will.
So it's the imperial we.
Welcome.
First of all, how do I do this? First of all, I sit on 2 school boards. I know the process, and you are not correct. Second of all, this is about the contract of Shonda Richardson Snell, and I deserve a right to say something about it. I don't understand the rush in signing this contract for an interim that could be held over. There is something going on underlying, and it's wrong. And I'm so tired of us not getting our voice heard.
Excuse me, ma'am. The items on the agenda
And I'm
are
speaking
to hire
about,
an attorney to help us with the contract. The other item is in regard to unwinding a contract with our culinary school. Those are the 2 items that are on there.
Mr. Chair, point of order. I believe she's moving towards a point, so why don't you let her make her point first, because you've just cut her off.
the point is there's not a need to hire counsel if we were to do this process correctly. We don't need to do this. We don't even need to have this as an agenda item because there should be public input as to who we have as our president of our college. So what we're speaking to, guess what? You can have people clap. It's okay. I'm just appalled at this process. I'm appalled at the fact that we look like idiots for this. Like, come on, Mott's better than this. Don't drag us through this. Do not. There's a personal agenda as far as this retention of counsel. Why? We have a board lawyer sitting right there. What are we paying him for? How much are we paying? This just makes no sense that we have to continue to do this charade when, seriously, do the right thing, take the foundation's offer, and have us go through the process and give us a say. We are taxpayers, and we vote, and we have a right to this. This is career suicide for Shonda, and I feel bad for her. 4-3 split vote, why would you even consider a contract with us right now? We're gonna get nothing done. Nothing will happen in the next few years with a board like this and a 4-3 consent vote, or 4-3 dissension vote. I've experienced it myself on a board several times. That's all I'm gonna say.
Thank you very much. Are there any other comments?
Yes, Mr. Chair, the next comment's been submitted by Glenn Harris of Flint, Michigan, on the topic of retention of counsel employment contract for president.
Oh, okay.
Welcome.
Proceeding with anything related to retaining counsel related to an employment contract presumes a lot that has not happened. It presumes a process, almost all of the steps of which you have not taken. The question of who is the best person to enter into a contract with as our new president, I don't know the answer to that. But I do know that you, the members of this board, also do not know the answer to that question. And I know that because you've shown no effort to arrive at a legitimate answer to that question. You hired an interim after a few minutes of deliberation with no explanation for your choice and with no accounting for your lack of process. Over many months now, as you decided to do it yourself, then decided to hire a search firm, then decided not to, as you have wasted weeks wondering how to write a thank you note for a gift of $250,000, as you have shown up to meetings not even having looked at proposals from professionals who would have done the job for much less than that amount, the one constant through all of this is that you've offered no explanation for your original choice or for your conclusion, the conclusion of 4 of you anyway, now that she is the right person. Last week at the end of the meeting, 3 of you in the majority had no comment. The chair did, just to say that when he asked a follow-up question about data-driven decision-making, she answered that question to his satisfaction. Are you serious? Really?
Absolutely, I
Are you
am.
serious? Because this is so ironic and so insulting. If you are such a fan of well-informed, data-driven decision-making, let's look at what that would look like in a vitally important hiring process. Any successful decision-making process must first establish a clear goal. In this case, something like a candidate profile that would emerge from a wide survey of all the constituent groups. Only that would allow for a proper evaluation and analysis of the information gathered about candidates. Any such properly informed process would involve a thorough vetting of all candidates' backgrounds and qualifications, something best left to the professionals of an outside third party. Any such well-informed and data-driven process would involve comprehensive interviews of and presentations from several qualified candidates with the transparent use of rubrics to evaluate those interviews at meetings open to the public and followed by careful review of qualitative and quantitative data derived from surveys of those in attendance. But now you have, to use Trustee Swanson's words, saddled the interim with the weight of the irresponsibility of 4 of these board members. And now she carries the weight of widespread distrust and the burden of continuing unanswered questions about this process and about why you have been so bent on gifting her the job. One other point I really need to address relates to some public comments you have heard at 2 recent meetings from supporters of the interim, several of whom cited her faith as some kind of qualification and completely falsely, I need to stress, totally baselessly, claiming that the board's critics opposed the interim because of her faith. The record is clear. Criticisms and questions have been focused entirely in 2 areas: the backgrounds and relevant qualifications of the original group of candidates, and primarily on the board's failure to conduct anything like a remotely reasonable process. And just as it would be wrong to disqualify someone in a hiring process because of their faith, it would be just as wrong, in fact, illegal discrimination, to count someone's particular religious faith as a qualification. So, might our interim be the best person for the job? Perhaps. But the only way to have a clear answer to that question would be to engage in an actual decision-making process, well-informed by all relevant data, like the searches that happen everywhere else when people are looking for a college president. Thank you.
Thank you very much. Are there any other comments?
Yes, Mr. Chair. The next comment's been submitted by Kathy Watchhorn of Flint, Michigan, on the topic of item 2.61.
This is on, yes. Good morning. My name is Kathy Watchhorn. I was born and raised in Flint, Michigan, and I am a proud graduate of both Mott Community College and the U of M Flint. My comment is in regard to agenda item 2.61, the retention of counsel for limited scope employment. And it is this: if the board's own rules of order and its procedures as laid out in the recent board meetings of October 7th and 8th and November 18th are being properly followed, then the interim president should not need her own counsel. Furthermore, and I address this comment specifically to Trustee Swanson, you were completely reasonable at the November 18 meeting when you said that we should not hang a flawed process on an incoming new president. Mr. Swanson, as the second top vote getter for this board in the recent election, you stated in your interview in M Live that you look forward to getting back to where the board gets along. Changing your vote on this contract is not the way to do that. You should stand by your good instinct, and you should not have changed your vote at the November 25th meeting. I urge you to stick to your original intent and to not continue with this flawed hiring process. Thank you.
Thank you. Are there any other comments?
Yes, Mr. Chair, the next comment has been submitted by Colleen Reinhardt on the topic of appointment of the interim president to permanent president. My name is Colleen Reinhardt. As a faculty member at Mott for 11 years, I am truly disappointed and disheartened in the board's decision to appoint a permanent president rather than conducting a search as previously promised. I believe we are entitled to a fair and transparent process that includes input from all Mott stakeholders, including ours. This unscrupulous process to appoint the candidate that only 4 of you deemed qualified is not in the best interest of Mott, our students, or the community we serve. I ask that you reconsider this decision and move forward with a fair and transparent search and hiring process. Thank you.
That clearly had a lot to do with our 2 items on the agenda today, didn't it?
I thought I would read and you would, or the board would determine when I
Do
stop.
we have another one?
Yes, Mr. Chair. Comments been, okay, that's already been done. From Paul Jordan of Linwood, Michigan, on the topic of, that's item 2.62. So Paul, if you're going to speak to the items on the agenda for this morning's meeting.
His comment is on item 2.62.
That's what's on here, but I didn't.
I'm sorry, that meeting is at 5:30 this evening.
No, the item is on, the comment is on, I've submitted 2 forms, one for this meeting and one for this afternoon's meeting. So I urge you to, I live in Flint. I live on Linwood, but I live in Flint. I urge you to defer to the incoming board the decision of whether to hire counsel to negotiate a contract with Ms. Richardson Snell. Choosing the president of such an important and respected institution as Mott Community College is something that must be done well. This has not been done well so far. We all know that when we want to know the truth, we should examine a person's or a board majority's actions and not just accept their words at face value. The majority of this board have acted as if Ms. Richardson Snell would never be selected as a final candidate by a professional search company based upon her qualifications. Actions speak louder than words. If they truly had faith in her, had the faith in her that they and others have proclaimed, they would be confident that she would prevail in an objective, competitive search process. The truth is that neither the members of the majority of this board nor those who spoke on her behalf really have the belief in her abilities and qualifications that they proclaim. Their actions reveal their true belief that she could only be appointed by hastily ramming it through as the majority has done. The duty of you trustees is not to have selected a candidate that closely reflects your personal values. According to your policy 1240, quote, "The board will act in the best interests of the college and the community as a whole," end quote. In this instance, this means that it is your duty to offer the position of president to the best qualified available candidate. A thorough process would result in selecting a candidate who would earn an overwhelming majority of the trustees' votes and not the slimmest majority possible. Following a normally thorough and validating search process, a new president could expect to enjoy a substantial honeymoon period devoid of doubts and conflict. That wouldn't be and necessarily could not be the case here because of how the majority has proceeded. Some of Ms. Richardson-Snell's advocates have attempted to trivialize her lack of any previous experience in institutions of higher education by claiming that both Dr. Walker-Graffia and Dr. Shank were also previously inexperienced in leadership at community colleges. At least one person questioned whether Dr. Walker-Graffia had earned her PhD in a solidly academic discipline. A brief web search reveals that in fact Dr. Walker-Graffia's PhD is in child development, and both she and Dr. Shank had substantial previous leadership experience in community colleges before being hired at Mott. As it stands, this lame duck board's haste in offering Ms. Richardson-Snell the position with the smallest possible majority of board support means that she would begin her tenure under a cloud. Instead of enjoying a honeymoon period where everyone would be inclined to give her the benefit of any doubt, everything that she does would be carefully scrutinized both within the college and by those in the community with whom she must work in order to be successful. By rushing to offer her the position, you have added a tremendous burden to those that any new college president would already have to carry. If she were to become the next president of the college, she would deserve to come to that position after a validating, objective scrutiny of her qualifications and after emerging from a field of qualified candidates. That validation by a search firm would earn her the overwhelming support of both trustees and the public. That could only happen after being selected as a finalist through a nationwide, professionally conducted, independent search. As the end of this board's term approaches, all of you, and the two outgoing trustees in particular, should ask yourselves if your votes regarding the search for Mott's next president have truly been in the best interest of the college and community as a whole. Your reputations and legacy are at stake here. Your actions will determine how you will be remembered. I therefore urge you to vote against appointing counsel to engage in contract negotiations with Ms. Richardson-Snell. Leave the issue for the next board.
Thank you very much. Are there any other comments?
Yes, Mr. Chair, the next comment's been submitted by Sandra Henley of Lincoln Avenue on the topic of Board of Trustees behavior not in the best interest of Mott Community College. Majority fails to take into consideration any recommendation they do not agree with. Board of Trustees suffering groupthink. Would you like me to proceed?
Does it have anything to do with the two items on the agenda?
I have not read it yet.
Okay,
So if
let's start.
Okay.
Start it.
we have all read the advertisements, free college for all, fancy advertisements aside, there is no such thing as free lunch. All choices have unintended consequences. My community college has a unique opportunity to utilize federal, state, and private resources provided to help mold the future. Provide solid foundation for students in the communities they serve. Multiple industries have suffered to fill roles required to keep our economy sustainable, cybersecurity, healthcare, teachers, and more. Mott College could pave the future for a greater tomorrow. Utilizing these resources, helping students rise to meet the demand ahead. Failing to implement these resources successfully could cause long-term damage, students, Mott College community, and lenders. Mott Community College requires a strong team to rise this unique opportunity, yet it is apparent we do not have that. I find it completely troubling that during a time of transition, unique opportunity, one board member with the following of few others has all control, purpose to serve their own agenda. I have watched meetings where others speak, voicing valid points. They do not listen, roll their eyes, even read us referred to as the peanut gallery. This is not the purpose of the Board of Trustees. Board of Trustees has obligations to serve and protect students, teachers, and community. Yet I hear horrible remarks made about teachers. Qualified teaching staff is another industry suffering. Yet our town...
Jordan,
Yes.
I don't believe she's addressing the two items that are on the agenda today.
Okay. The next comment has been submitted by Bobby Walton of Davison, Michigan, on the topic of investment in contracts.
Before I begin my comments, I want to remind the chair that some months ago, I was gavelled down twice because I was saying something you didn't like. And at a subsequent meeting, I brought a copy of a court case that was decided in Michigan that has been used by school boards throughout the state as the standard
Excuse
for
me,
allowing
Bobby.
public comment.
Today, we're talking about two items.
Yes, and I'm talking about you
2.60
gaveling
and
people down and making
2.61.
them be quiet.
Please address
You're
your
violating
comments
the
to
law.
that. Bobby?
You are violating
Bobby?
the law. Do not shake your finger
One
at me.
more. Get back to what we need to for today.
Then you
That's
have
all
me
we're talking
removed?
about.
I will start my comments, and then I will conclude them. When I looked at the agenda for this morning's meeting, I was interested in both issues. I would like to know more about the investment related to the Culinary Arts program. I would like more detail about how this investment plays a role in our investment in the Culinary Arts program. Are we exercising an investment option, and why? I understand why you need to authorize the interim president to sign the paperwork. She is not the president, even though you have tried to make her the president, which is my second concern, and that is the judgment you have shown in your recent vote to install Shonda Richardson Snell in the role of president for 3 years. If you were charged with issuing driver's licenses, you would be fired if you approved the issuance of a license to someone who had only read about driving. If they had not experienced the handling of a vehicle, they would be a danger to themselves and others, and so it is here. A lot of skill is developed with experience, but I believe the most valuable skill is knowing how to react to emergencies or unplanned changes in circumstances. An experienced manager knows how to react to this instinctively. Former President Dr. Beverly showed how this was done when she brought the staff, faculty, and board together to help the college make it through the COVID crisis. This kind of skill does not come from only reading about it. Reflexive response and judgment comes from experience. I have seen professional captains take a vessel through threatening storms on the water. I was glad they had been tested through experience before I boarded. Further, I was glad they had worked their way up the ladder before they were licensed to captain a vessel. Shonda Richardson Snell does not have this kind of experience in the environment of a public college. She has not worked her way up the ladder on this vessel, and I am protesting that you have given her the helm. You have heard from me and others what our expectations of you have been. We expect professional behavior. We expect professional use of the authority the public has given you when we voted for you. We expect a transparent process involving the community of stakeholders in the outcome. We have shared these expectations with you over the last several months, yet you have brushed our concerns aside like so much dandruff on your shoulders. We are a nuisance and unsightly. In fact, you have not hidden your disdain for our participation in the process, which is hardly collaborative. It must not be a surprise to you that you will continue to
Bobby,
hear
we have
from
two
me.
items on the agenda today.
I
Item
further believe this board
2.60
will
and
continue to hear from a
2.61.
concerned public
You are off topic,
and
Bobby.
others with a stake in the future of Mott College.
Bobby,
I
point
guess
time
we
is now.
expect
Point of
you
order.
to learn through
Point of order.
experience.
Point of order.
Your
Mr.
point of
Chair.
order.
I have actually heard her referring to topics on the agenda. Why are you interrupting her?
Because she's diverted from the agenda.
Everything's
Mr.
interesting to
Freeman, my
me.
ruling is she diverted from the agenda. Thank you very much.
I guess
Bobby,
we
thank you very
expect you to
much.
learn through experience that we are not going away. Remember, you are a public institution situated on public property. It is not unreasonable to expect the public to exercise our First Amendment rights to speak and assemble, and we will be fierce and dogged in our protection of these rights.
Thank you very much. Are there any other comments today?
It was my pleasure.
Yes, Mr. Chair. The next comment has been submitted by James Schurter, Grand Lake, Michigan, on the topic of 3-year contract appointing the interim president as the permanent president.
I'm sorry, the topic is what?
3-year contract appointing the interim president as the president.
I don't believe that is on the agenda today.
Mr. Chair, again,
Trustee Freeman.
you're censoring again where it is relevant to the contract that you're suggesting we go into in hiring an attorney. We'll have a conversation about that one later, but you're censoring.
Is it a written comment?
It was submitted for me to read, yes.
Let's start it and see where it goes.
Board of Trustees, Mott Community College, dear members of the Board of Trustees. I am writing to express my profound disappointment and concern regarding your recent decision to offer a 3-year contract, appointing the interim president as the permanent president of Mott Community College. This decision lacks transparency and stakeholder involvement that our college community was assured of and deserves. The abrupt appointment without a formal review of the interim president's performance and the abandonment of the national search raises serious questions. A fair, thorough, and...
Jordan?
Yes.
It does not seem to have anything to do with item 2.60 or 2.61. Thank you very much.
Okay. James Schurter submitted another comment, but that is for 5:30 p.m. All right, the next comment has been submitted by Julie Steffi of Fenton on the reconsidering the interim president's installation as president. So that is clearly for next meeting, unless she says she'll make it in person, but if she's here, but I assume she's making it for 5:30. And I apologize, there's no distinction between 5:30 and 10 a.m. on these submissions.
Okay.
All right, the next comment has been submitted by Stu Mitchell on the topic of permanent president selection process. My name is Stu Mitchell, and I'm a faculty member at MCC. I am disappointed in the board's decision to appoint a permanent president without conducting a search process. This has been promised at several points during previous meetings. We deserve a fair and transparent process that includes input from all of Mott's stakeholders, especially from faculty, staff, and students. This process, or lack thereof, to appoint a candidate without the aforementioned consideration is not in the best interest of Mott. I ask that you reconsider this decision and move forward with a fair and transparent search and hiring process. Thank you for your time.
And that one, once again, had nothing to do with our agenda.
I'm waiting and...
Next, go to the next.
Okay. Next comment has been submitted by Rachel Lehman of Goodell's, Michigan, on the topic of national search for the next college president.
I am here, and it does have to do with retention of counsel. If I may speak? Good morning. My name is Rachel Lehman. I've been involved in higher academia for 25 years, over 25 years, and I've been here at Mott for my last 21. I'm here to speak against the retention of counsel for a contract offer. One of the things I do to remain current in my field as a faculty member is attend national conferences. And when I began doing that as a representative for Mott College, it was impressive to me how far-reaching our good reputation is. I would go to these national conferences, people would see my name badge, and they would say, "Oh, Mott College," and they were impressed by it. And then they would say, "Where is that?" And I would say, "Flint." And they would say, "Flint, Michigan?" I would say, "Yes." The ensuing conversations ranged from the exodus of the auto industry to our ranking on national homicide statistics to the Flint water crisis. But I will tell you that in more recent conversations, the spotlight is no longer on the city, it is now on this board. When people ask me about Mott College, they talk about the entertainment value of the board meetings. They ask about how the climate on campus is. They ask about why we didn't have a rubric for our search during an interim president. They, as of last week, ask what happened to the national search that you were going to do. And they ask me, given all of this, are you concerned with your accreditation in HLC? And my answer is yes. Now, the personality differences on this board aside, you can write this. You can do the formal search. You can take the Mott Foundation up on its very generous offer, hire an outside firm that will do a widespread, transparent process, getting input from all the legitimate stakeholders. As the governing body of this college, you owe it to this college. Okay. You owe it to the students who come here expecting the best. You owe it to the staff and to the faculty who are here to do this work because we're trying to help our students and we're trying to serve our community. You owe it to this community who we exist to serve. You owe it to this community, and you owe it to interim President Snell. Because if you install her in this manner right now with a 4-3 split board vote, if you install her in this manner, you saddle her with
Could
that
you help
legacy.
us on item 2.60 and 2.61? This seems to have diverged from public comments today are to be on those two items and those two items only. You've diverged into other topics here. Please bring it back to those two items.
I am at this moment, sir. Thank you. You owe it to her to let her earn this position through a legitimate search. I'm asking you to hold off from retaining counsel to create an offer and let her go through the process. Whatever she does here, if she's put in this manner, is going to be shrouded with suspicion. Any good you do is going to be shrouded with that. I would like, again, as someone mentioned earlier, it might be political, or it might be career suicide for you to be put in this way. And I urge the board to hold off, to do a proper search, let her earn her place at it, so that what she does could be looked at with an air of legitimacy instead of suspicion. Thank you.
Thank you. Do we have any other comments?
Yes, Mr. Chair. The next comment has been submitted by Dr. Mara Javera, or Dr. Mara Fulmer, Grand Blanc, Michigan, on the topic of presidential hiring process. And I will read until,
Let's read the first paragraph and see where we're going.
okay. Note, this is being submitted for the 10 a.m. meeting on 12/2. I am Dr. Mara Javera Fulmer of Atlas, Michigan, mailing address Grand Blanc, and a longtime faculty member here at Mott. I am writing to you today to talk about process, something that should be taken seriously in order to achieve the most effective outcome possible. Let me share a story about how not following the process went in one of my classes recently. I teach graphic design, and the process of developing...
Jordan?
Yes.
This is about process. This isn't about 2.60 or 2.61. Thank you.
The next comment has been submitted by Lynn Wandry of Flint, Michigan, and the topic is also presidential hiring process. My name is Lynn Wandry, and I have been a full-time faculty member at Mott for 21 years. When going through the hiring process, when I came to Mott, I was among a number of qualified candidates. While I don't know the details of the other candidates, I do know that a nationwide search was conducted, and I went through several rounds of phone and in-person interviews. If this is the process of for hiring one professor, shouldn't we expect as much more when hiring the leader of this institution? This decision to simply appoint a permanent president without any type of search is truly...
Jordan?
Yes.
That doesn't seem to have anything to do with item 2.60 or 2.61.
The next comment has been submitted by Carrie Devon of Charing Cross Drive on the topic of president selection process.
Can you hear me? Good morning. It is with a very heavy heart that I am here today. My name is Carrie Devon, and as a faculty member at Mott Community College, I am beyond disappointed in the board's decision to retain counsel to hire or review the contract for Shonda Richardson Snell. Ms. Snell, I just want to talk to you for a second. You and I did not really get off to the best start, and we both know why. But I do feel bad for you to be in the situation that you're in right now. To have to retain counsel to review your contract for a job that maybe you are qualified for, maybe you're not, I don't know. But this whole process has just been wrong. And I support women. I support achievements more than you would ever know. But I can't imagine that you would want to get this job like this. I can't imagine that you would be happy that your career might be tainted by a faulty way of hiring you into a position that is so coveted. I just can't imagine that that's how you want to go out like this. There should be no need to retain counsel when you do the right thing. There should be no need to scurry the process if, in fact, you know that you're hiring the best person for the job. Maybe you are the best person. We don't know, but we would like to find out. I'm a former athlete. In my mind, I'm still an athlete. I'm very competitive. I would want to earn the position. I would want to win fair and square. Have at it. Open up the doors. We were given up to $250,000. Up to $250,000 to find the best candidate for this position. Throw your hat in the ring, along with others, in a national search. You deserve it. Mott deserves it. The community deserves it. You deserve to earn the position. You deserve to throw your hat in the ring. You deserve to, pound on your chest if you actually win the role of the president of president of Mott Community College. I would imagine that that's how you would want to go out. and not have your reputation tainted by this process. That's all I really have to say. Thank you.
Thank you very much. Do we have any other comments this morning?
Yes, Mr. Chair. The next comment has been submitted by, Janet Westoff of Mountain Avenue on the topic of presidential search process. Okay. All right, the next comment has been submitted by Lisa Banks of Grand Blanc, Michigan, on the topic of presidential hiring process. My name is Lisa Banks. I'm proud faculty member at Mott Community College. I'm writing to voice my concern over the board's vote to backtrack on their previous public decision to conduct a nationwide search for the best possible presidential candidates. The traditional process is arduous for a reason. We need to find, then vet candidates in order to select someone who best knows this industry, both educationally and experimentally, and who is the best fit for the community and this college. This board is not qualified nor capable of completing. Yes.
Doesn't seem to have anything to do with the two items, 2.60 and 2.61.
Next comment has been submitted by Phil Nolf of Brighton, Michigan, on the topic of presidential search process. Observing the operation of this board over the last year has been like observing a petri dish of faulty group processes. There's no transparency on decisions made by the board majority. The 4 board members owe an explanation for bypassing a best practice search for a president.
Jordan?
Yes.
I don't think that has anything to do with 2.60 and 2.61 either.
Next comment's been submitted by Alana Ferguson of Grand Blanc on the topic of hiring of interim president. I would like to strongly encourage the board to follow best practices and complete a proper hiring process for our next president. When hiring a high-level position, it is important to include a variety of stakeholders. I am disappointed that the board verbally accepted the offer from the foundation to hire a search firm, but has not followed up. My hope is beginning to fade, but I will continue to pray that our organization does right in the end. I just ask that the board consider the effects of appointed versus a proper search, a diverse interview committee, and candidate forums. All things we have done in the past for president and vice president positions. Thank you for your time.
Do we have any other comments?
Yes, Mr. Chair. The next comment's been submitted by Amanda Leemaster of Holly, Michigan. 5:30, okay. All right, the next comment has been submitted by Catherine Amboy of Flint, Michigan, on the topic of presidential hiring process. My name is Kathy Amboy, and as a faculty member at Mott for 15 years, I am truly disappointed in this board's decision to appoint a permanent president rather than conducting a search as you promised all along.
Jordan?
Yes.
Doesn't seem to have anything to do with 2.60 and 2.61.
The next comment has been submitted by Candace Minoz of Court Street, Flint, Michigan, on the topic of national search firm for presidential search. Hello, I'm writing because I have been a faculty member at Mott for 15 years and a longtime supporter of educational opportunities in the greater Flint area. I have had the opportunity to participate in the MCC Centennial Celebration events last year, which brought students, faculty, and staff together to celebrate 100 years of academic excellence in the community. However, recent board decisions have tarnished Mott's great reputation in the community. I am truly disappointed in this board's decision to appoint a permanent president rather than conducting a search.
Jordan?
Yes.
It has nothing to do with it.
Next comment has been submitted by Kim Owens, Flint, Michigan, on the topic of contract for president.
Good morning.
Morning.
I'm here regarding the contract that will be offered presumably at some point since you're retaining counsel. I have come to you, the Board of Trustees, over the last couple of years, disappointed in your actions. Today I'm just outraged. You have completely ignored public outcry as well as your own decision to conduct a proper...
Excuse me, ma'am.
I'm getting there.
This is about item 2.60
I'm getting there.
and 2.61.
I am getting there. To conduct a proper presidential search. And now you need to retain counsel to review a contract offer because you did not do the right thing. Instead, 4 people with no higher ed experience appointed one. There was no rationale, no process, no transparency, and no input from stakeholders. Presumably, this is why you need to retain counsel. This appointment reeks of corruption and apathy. Your actions have completely eroded the trust between you, our governing body, and those who you are supposed to govern. And I assume that's why you need to retain counsel. If this appointment stands, you are setting up this president for a tenure rife with suspicion, fear, and mistrust, which again, I assume that is why you have to retain counsel. And who will pay the price? Besides the lawyer or the college, because you have to retain counsel again, who will pay the price for this? Students, faculty, staff in this community. The very people you are supposed to serve, but instead have arrogantly and willfully ignored. We demand a fair, transparent, and legitimate process in hiring, not appointing, the next president. Presumably, if you do that, you will not have to hire counsel.
Thank you very much. Are there any other comments?
Yes, Mr. Chair. The next comment has been submitted by Hope Demaro, Montrose, Michigan, on the topic, the hiring of Shonda Richardson Snell. I think that would be for 5:30. I am a proud alumni of Mott Community College. This board's decision to change course after choosing to accept this generous donation from the Charles Stewart Mott Foundation is a mistake.
Jordan?
Yes. Next comment's been submitted by Jenna Andrews of North State Road on the topic of transparency and hiring. As a professor at Mott for 8 years, I am truly disappointed in the board's decision to appoint a permanent president rather than conducting a search as you have promised all along. We deserve a fair and transparent process that includes input from all of Mott's stakeholders, including ours. This corrupt process to appoint a candidate that only 4 of
Jordan?
you... Yes.
Doesn't fulfill 2.60 and 2.61.
Next comment's been submitted by Angie Wilhelm on the topic, or of Chandler Avenue, on the topic process for hiring. As an employee of the college, I am choosing not to share my name for fear of retaliation. I am once again disappointed in the conduct of this current board, with the exception of a few individuals. The past 2 years have been alarming for employees. The college has processes in place for ordering technology, a process for purchasing, a process for grants, a process for changes to curriculum, and so on. We have them in place so we can be consistent in our decisions and show taxpayers we are making the best decisions.
Jordan?
Yes.
This doesn't fit either.
And that concludes public comments.
Thank you very much. Business of special meeting. authorization for interim president to sign required documents in connection with the investment fund put call agreement dated November 29th, 2017, related to the Culinary Arts Building, as has been advised by legal counsel. The background. Interim President Shonda Richardson Snell requested that this item be placed on this morning's agenda. There is a deadline of December 3rd that needs to be met in connection with the 2017 transaction involving the Culinary Arts Building. In 2017, the board authorized the investment fund put call agreement as part of the transaction. Now, certain documents must be signed to unwind the transaction. And Interim President Richardson Snell has requested that we authorize this and authorize her to execute the necessary papers. She will provide more information about this matter. But first, we need to place a motion on the floor. Therefore, I entertain a motion that the transaction
Mr. Chair, point of
shall
information.
proceed as
Point of
originally
information.
authorized.
Point of information.
And the interim president
You have to
shall
rec-
Richardson
point of
Snell shall have full
information.
authority to exercise the necessary
Bill Brickley,
documents.
point of information.
Is it so moved?
Point of information. Are we going to get a presentation about this?
As soon
Like
as we have a
usually-
do we
usually
have a so moved so
A
that the motion can
presentation
be
is
placed on
usually
the floor
provided to
for
us.
discussion?
Like Larry's been with us since the very beginning. Point of information that you didn't recognize.
Oh, I didn't see you over
Usually,
there.
Larry usually, he's actually worked with us the whole time. Can we get a presentation on this?
As soon as we have a motion on the floor.
No, That's
We
not,
have no
the- that's
motion
not,
on
no,
the
no.
floor yet.
That
Do we
usually,
have-
the
I am
motion,
entertaining
motions
a
are made
motion.
once we've been
Is there an
informed.
entertaining of a motion
Oh, my
to move
God.
this forward? Going once.
So moved.
We have a motion. Do we have a second? Do we have a second?
Jesus Christ.
Are we going to get a presentation?
Yeah, you get your set, you'll get that when we do this.
Second.
Okay. Shonda can explain and answer the questions.
With us here today is Dickinson Wright, who was involved in the original transaction in 2017, and also General Counsel for Mott Community College, John Godola.
Welcome, gentlemen.
And we do have Larry Gotham present as well.
Yes.
Good
Do you
morning.
need Larry up at your table with you now?
I think he's prepared if we need him.
Okay.
Good morning to the interim president, to the chair, and to the board of trustees. In 2017, there was a resolution presented to the board of trustees that allowed Dr. Beverly Walker Graffia to enter into an agreement regarding the Culinary Arts Building. That agreement included a substantial financial contribution from the Mott Foundation that allowed the Culinary Arts Building and the program to start. That agreement was entered again on November 27th of 2017, or excuse me, yeah, November 27th of 2017. That process is now pursuant to that agreement coming to a close, where the unwind process also requires signature of the interim president, which is what we are asking today, is that the interim president be given the authority to sign the documents related to the unwinding process that was started in November of 2017. With me is Attorney Craig Hammond, who was present back in 2017 from the Dickinson Wright Law Firm. Fortunately, we have him present. Not only was he present then, but he's present today to explain the process and answer questions if you have them.
Trustees, are there any questions? Trustee Reyes.
I have a question. Yeah, I'd like to hear the presentation.
So do you want me to just overview of the transaction and why we're here today at this stage? So this was what's referred to as a federal new market tax credit transaction, where because the city of Flint qualified for this type of federal tax credit, the state of Michigan contributed $1.5 million. The Mott Foundation contributed $4 million. Mott Community College contributed $400,000. Those funds were all then loaned into what was called an investment fund, and then J.P. Morgan Chase invested into this investment fund in order to qualify for federal tax credits, for which they paid another $3.4 million. All of that resulted in about $9.8 million of capital being raised that was used to renovate the Woolworth building downtown and turn it into the Culinary Arts Building. And the college entered into a lease, it currently has a lease of that building, but doesn't own it. It's owned by a limited liability company that was created in order for these tax credits to be realized. So it's a complicated structure, but this was a way to get a big federal development incentive program to help raise money for this project. But the deal always was there was a 7-year tax credit period. The project worked. The college has been using it. The investments were made. The building was renovated. But at the end of 7 years, the deal was that the Mott Community College would buy out Chase's interest in this limited liability company so that Chase could exit. Senair is also involved. There was, without getting too much of a complicated structure, you had both Chase and Senair participating in this transaction in order to realize the tax credits. And at the end of 7 years, they've benefited from the tax credits, and now they want to exit. And this is step one of their exit, so of the college taking over ownership, basically becoming the holder of the loan. So by doing this, the college will become the holder of the mortgage loan. And then we'll be coming back to this board for approval for the college to acquire the building in forgiveness of the loan. So the second step will be the college will then own the building, and we're hoping to accomplish that approval at the next meeting. So it's a good result for the college. Instead of paying rent in this building, you're going to become the owner of the building, no longer obligated to pay rent, and frankly, you're fulfilling an agreement you entered into in 2017 that you would purchase out Chase. So this investment fund put agreement was that was part of the transaction, that the college would purchase Chase's interest in this investment fund, and the purchase price is $1,000 plus the legal fees of the transaction. So it's not, in the big picture, it's not a big outlay of cash that you're doing to do this transaction.
And I might add that the legal fees for Chase are approximately $15,000, and for Senair, roughly $3,000 plus the $1,000. So it's a total closing cost of roughly $20,000. The transition of the ownership of the building, one of my questions was why that couldn't occur at the same time as the unwind. So the loans become Mott as the obligor. And so perhaps, Craig, you could explain further the next phase of the anticipated transaction in which the ownership of the Culinary Arts building becomes property of Mott, and assurances of that occurring.
So currently the owner of the building is a limited liability company referred to as 550 Bears. 550 Bears is 90% owned by Downriver Reinvestment Corporation, which is a subsidiary of Uptown Reinvestment Corporation, which is an affiliate of the Mott Foundation. They were really the developer that spearheaded this. And 10% is owned by the Foundation for Mott Community College. In order to meet federal tax requirements, there had to be a true operating lease between the landlord and the college. So the college doesn't have it wasn't a lease purchase agreement. It was a true operating lease. And that operating lease was a 30-year lease, and it's in place right now. But the intention of the parties was that 550 Bears didn't want to continue to own the building, that they would convey it, and the intention is that they're preparing an agreement to convey the property. They want to put the right of first refusal on the agreement, so if the college ceases to use the building for its educational purposes within the next 10 years, that the foundation or Downriver Community Conference would have a right to meet any purchase offer. So that's an agreement that the board will be approving. But our intention was to bring that back here in December. And that's step 2 of the transaction that we're expecting. But this first step here would put the college in the position of being the holder of the debt, so that by holding the debt, basically the rent they pay would cycle through, and there's no economic reason for the property to not be transferred, because they're the holder of the mortgage loan as well as paying the rent through their lease. So I know it's complicated, but
Trustee Freeman has a question for you.
So I've actually worked with Senair and New Market tax credits for many years. I'm pretty familiar with, I know it is complicated, and also kind of the structure that this is how we set this up. So first question is, do we have, with mezzanine financing, were there historic tax credits? Were there other tax credits that will also require an unwind?
No, these were the only tax credits.
These are the only tax credits. And the second question is related to the right of first refusal or purchase. Can you go into a little bit more detail on, I understand the provision about no longer using it as an educational facility, which was the intention philanthropically. I understand that. But also just give us a little bit more detail on what will all be included within that right of first refusal and any condition that would have us lose any equity that we have built up into this.
So the right of first refusal agreement has been, we don't have it agreed upon yet, but it's, that is to be coming soon, and we'll be coming back to the board presenting it when we have the terms, so I don't want to get too ahead of myself. But my understanding of the business deal is that Mott Foundation feels they put $4 million in this project, and they want, I think of this as sort of a grant restriction, that if you're not going to continue to use the building for educational purposes, they'd like to have a right of first refusal where they could match a purchase price. And that would burn off after 10 years. It would go away then, but for the next 10 years, that's what they're, and they do have the leverage, to make this request because they control the entity that would be transferring the property over. But I think there's been a discussion, and I think, Larry's participated in it, and I think that's the arrangement.
So I believe you're probably counsel for the limited liability corporation,
No, I'm the college's counsel.
You're our counsel.
The limited liability company does have its own separate counsel.
Okay. Do you know who their counsel is?
Ken Beal.
Oh, he's great.
Yeah.
He's really good.
Mhm.
Yes. Well, that's why we have to have a good attorney on our side too.
No, he's been fine.
Yeah. It should be fine. Okay. Yeah, and my only question is just like, why weren't we prepped a little bit earlier for this? Because December 3rd is tomorrow.
Yeah,
We
that was
probably we should have been told about this a little bit earlier because this is, a little bit to digest for sure.
I agree, Trustee Freeman. It was brought to me with, on Tuesday afternoon last week, day before the break for the holiday. So that was why I brought this forward for board review on Wednesday with the arrangement for the special meeting this morning so that the board could be made aware of the details and provide confirmation that the resolution that was approved by the board in 2017 does in fact provide me with the authority to enter into the put-call agreement to unwind the transaction. And the deadline was proposed by, as I understand it, and Craig can provide additional detail, was proposed by Chase, and their intent is to close tomorrow. So I was provided with that date and desired closing time last Tuesday, late afternoon.
I have a question.
Trustee Daley?
I'm going to support this very reluctantly because I believe it supports a good program. And this is no reflection on Dickinson and Wright. I'm not going to buy the fact that this just came in the door and we get it at the last minute. We got this, the proposed contract for the attorney on Saturday. We should at least have gotten this. I'm serving notice right now to you and the staff that this is the last time I'm going to do this. Okay? Those of you that are here will remember the debacle called Oracle. And all of this works fine if everything goes right, but you try right now finding somebody that was responsible for the debacle with Oracle. And success has 1,000 fathers, and disaster is an orphan. You can't do it. We should be getting these in a timely manner. And we should be getting an executive summary on there that translates the legalese into the normal language that the board would understand, a summary of what's going on. This type of business this is not a good way to do business, period.
Any other trustees with a question? I have a question. Who's been taking care of the maintenance of the building?
Should I move?
The maintenance has been contracted out through Uptown Reinvestment Corporation, who's been handling the maintenance, the security as well.
Who picks up the cost?
We do,
We pick up the cost.
yes,
And was that part of the agreement?
yes.
So we're getting a building back now that has a leaky roof. The sidewalk drains into the building, causing the foundation to start crumbling. We have something black in the basement that we don't know what it is. And we're taking a building that's a pig in a poke.
Well, I have a structural engineering report that you requested. It's been completed, and there's nothing wrong with the building.
Have you gone down and looked at it?
I'm not a structural engineer, Chair. I
Well,
trust,
you can see the beams, you can see everything's crumbling. So the structural engineer can say it. But there's another building downtown that fell in that belonged to Rowe Engineering, and they were structural engineers. So I'm concerned for the cost of the future for the college. Trustee Freeman.
Mr. Chair, to your point, specific to the structural engineer report, I think we should probably look at that before we make assumptions, because right now, no one knows what's in that until they've actually looked at that. Just as there's a motion on the floor, and I'm assuming this is part of our discussion within the presentation, I know that the legal firm that we've retained is excellent. Kim Beal is one of the most ethical and appropriate attorneys that has worked with this program since the very beginning. I understand the need for the unwind and kind of moving into this next phase. So I'm fine with that. I think that the only thing that I would really want to make sure, to your point, Trustee Daly, is that when it comes to looking at the agreement or the language which is built into the right of first refusal, that we have a little bit more time to respond to that. I mean, this is really just more of a function, that we're performing so we can move to that next point. But really where the rubber hits the road is under which conditions actually, are we agreeing to exit people out, recognizing that the Mott Foundation made a very generous contribution into this, which benefits the college, and it's really, they've put more into it than we have. And also to the point of maintenance, typically the maintenance, as we are tenants, maintenance was agreed to be handled by they're the manager, like within this limited liability corporation. And in many cases, you ensure that the manager has the ability to control that, because if the tenant actually does anything to damage that structure, it's upon them. And that puts at risk the tax credits, because essentially you have to deliver it for the full term. And then if you don't deliver it for the full term that you suggested, then, that is a threat to the purchase of our tax credits. That's why that is actually outsourced, so that they have the assurance, they've made the guarantees that it's going to be kept up. And if there is damage which is related to that management of the facility, it's not our problem. They have to deliver the property to us in the condition that it was supposed to be. And if there's a maintenance issue, then they can go upon the insurance, which the maintenance providers have given, whatnot. But I understand exactly why we did that. So I myself, I'm fine with that. I do want to have, to make sure, Larry, since you've been with this since the very beginning, I would have a lot more confidence with independent analysis that the board is doing the right thing, because you've been here since the very beginning and you understand the structure better than anyone on this board.
So if I may, Chair, Interim President, I'd like to respond to Trustee Daly. While this looks like, and I understand why you're saying that this is last minute, I've been speaking with Craig from Dickinson Wright. We determined that from the legality standpoint, that this was a process, a function that had to occur because that was adopted on the 17, or in 2017. So that's why we did not bring this any earlier. It was a function of the agreement, and had we not exercised it, actually, we would have been in default of that put buy put agreement. So that's why we did not bring it. The conveyance of the property clearly was something that we had to do, and that's what I've been working on. And with the structural engineering certificate that we have to bring to you, when that was requested of, do we want to take on a building that has potentially a lot of problems, which is, legitimate. So we did that as well. So we were working on bringing that part here because the board clearly has to accept the property. But as far as this portion of the deal, the first step, was a function of what already happened in 2017. That's the reason.
The only thing I can say in response is, and I'm only speaking for me, that when you bring me something, you should expect the same level of scrutiny that I do all along. And I think that, to be candid with you, it's to get less than 24 hours notice of a drop dead date. And the first time I'm looking at the contract is when I walk in the door for the meeting, is really not an acceptable way to do business. And I would also encourage you to, on matters of this type, to include an executive summary, simply so that it's on record, because I'll guarantee you, if you go back 10 days from now and ask everybody in this group what was said at this time about this subject, you will get 10 different answers. Right. And that way, at least it solidifies it a little bit. So please, 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 don't put us in the position of where we're literally having to rubber stamp something.
And the only point I'm trying to make, and I agree with you, and I understand what you're saying, the only point I'm trying to make right now is that if there's something that in this transaction that you feel like you were hurried on or didn't get enough information, that was solely me, because we made the determination that this. Okay, so I want that to be very clear.
Are there any other questions? No further comments? Any other comments?
I was just going to add that the purpose of this was just to ensure that the board was conveying authority according to the original resolution that was approved back in 2017 to me as well. Dr. Beverly's name was specifically referenced in the resolution. So the whole of today's request is simply to confirm the board's conveyance to allow me authority.
Again, I understand that, and if I felt differently, I certainly wouldn't support it. But what I'm complaining about is the timing.
Agreed. I complained as well last week.
No further questions, comments, or discussion? Thank you all. Roll call vote. Trustee Reyes.
Yes.
Trustee Freeman.
Yes.
Trustee Couch.
Yes.
Trustee Daly.
Yes.
Trustee Walcott.
Yes.
Trustee Swanson.
Yes.
And Trustee Overman, yes. Passes unanimously. Item 2.61, retention of counsel for limited scope employment related to contract offer to interim president Shonda Richardson Snell. As background for this matter,
Point of order.
it became necessary to seek out legal counsel in connection with the contract offered to interim president Shonda Richardson Snell when current board attorney advised the chair, me, that he refused to serve as board counsel for the contract. Given that hiring of a new president is one of the most important duties the board has, and given that it would not be prudent to not have legal counsel at this junction, in my capacity as chair of the board, to exercise other powers as properly pertain to the office, Board Policy 1320, I arranged for a free consultation with Lynn McGuire from Butzel and Long last Tuesday. I was impressed with her and the firm, and therefore I recommend that Butzel Long be retained to provide legal counsel with regard to contract offer.
Mr. Chair, I think there's someone called point of order.
I'm sorry, I didn't hear it. I was reading.
Oh, well.
Do you have your hearing assistant say plugged in? I was just curious.
I'm sorry?
Do you have your hearing aid plugged in?
Yes, I have this
Okay,
one.
I just wanted to be sure. Well,
Did you have your microphone on? I didn't hear you.
absolutely.
Sorry, I apologize.
Not accepted.
Okay. So,
You still have a point of order on the floor.
oh,
You'd like to address that, or are we going to
well,
bypass
sure,
it
let's hear your
again?
point of order.
My point of order is that it's come to my attention that there are faults in this process and concerning the selection process. It is, I have screened those with outside legal counsel, and they've indicated to me that there is a conflict of interest that does exist. Therefore, I'm requesting that Trustee Couch be removed from consideration, discussion, and any voting or making of a motion on this matter. Also, as part of that, I would also indicate that I've filed 2 complaints against the chair personally for his actions in this.
Trustee Daly, I rule that you're out of order on that. I rule that under policy 1361 and 1325, there is a process by which conflict of interest are handled, not in a public meeting. The conflict of interest is submitted to the chair, and then the chair will do the investigation. And if it's deemed that it needs to come to the board, it'll come to the board.
So you have received notice of this conflict?
As so eloquently at our previous meeting, you and 2 other gentlemen spoke to the importance of process to be followed. The process that to be followed is in our policy manual as it relates to conflict of interest, which is item 1361. Code of conduct is 1325. You, sir, have violated both of those, and you violated the confidentiality
Mr. Chair?
of this board.
Mr. Chair?
Absolutely not.
There has been no violation. In fact, I've heard from numerous sources outside of this body that they believe that a conflict of interest exists. So I would like to hear from our board attorney related to conflict of interest and process. I don't want to hear your interpretation, Andy. I want to hear from our attorney on what should happen and what should be disclosed and how should it have been disclosed.
You've not been called upon yet. I am deciding.
Mr. Chair, I have a
Excuse me.
question.
This lady has a comment to us.
I believe that the chair ruled that Trustee Daly's point of order was out of order, therefore we move on beyond those comments. I don't know if Trustee Freeman has his own point of order or point of information.
I did ask that. So, point of information, I would like to hear from our attorney about what constitutes conflict of interest and what things need to be acted on and upon. Because if there was a conflict of interest, it invalidates everything. And, you know, there will be more eyes upon this at this point. So I'd rather that we start right now doing stuff by the book. And I'd like to hear from our legal counsel on what constitutes by the book.
Conflict of interest, Trustee Freeman, is 1361.
No, I would like to hear from our attorney.
Trustee
I don't want to
Freeman,
hear from
I
you.
am
This is your
speaking. Trustee
interpretation.
Freeman, you are
I have
now
asked
out of
point of
order.
order. I've asked a point of order from our attorney.
And I've ruled that right now I'm answering it.
But your ruling on something is a potential issue if we don't all have the same legal counsel and we hear what exactly constitutes conflict of interest.
Okay. Mr. Attorney, conflict of interest as it relates to item 1361 in our bylaws.
So keep in mind, this is the conflict of interest that you folks have defined. This is not state law. This is the conflict of interest provision that the Board of Trustees has adopted to be followed. It says, board members must avoid any conflict of interest with respect to their fiduciary responsibility, or board members shall be considered to have a conflict of interest if the board member or other person in a familiar or otherwise significant relationship with the board member has existing or potential financial or other interests, which might impair or might reasonably appear to impair the board member's independent, unbiased judgment in the discharge of his or her responsibilities to the college. This is, again, I will indicate that I have done a detailed legal memorandum to the board about this issue, which I disclosed facts and further legal analysis. I will not divulge that information without approval of the full board indicating that I can disclose attorney-client privilege. I can state in a general rule, in a general standard, which is acceptable and does not violate any attorney-client privilege, that this applies not only to a board member, but it applies to a family member of the board member. It applies to not only existing financial difficulties, but also potential financial difficulties. And furthermore, not only those which actually appear to impair the board member's independent judgment, but those might reasonably appear to impair the board member's independent and unbiased judgment. With respect to the issue of disclosure, Section 6, board policy indicates that all board members shall have the responsibility to ensure that the board is made aware of situations that involve personal, financial, or other business relationships that could be of concern to the college. That is an obligation that each board member has, and it's an obligation that they owe to each other board member and to the board as a whole. When a board member determines that the possibility of a conflict of interest exists, the board member shall disclose the potential interest and thereafter shall abstain from participation in both the discussion of the matter and the vote thereon. So again, when a conflict of interest exists, as defined in the policy, the board member shall not be involved in votes on the matter. Furthermore, it goes on to state that if the board member has any concern regarding a conflict, if a conflict exists, the board member should consult with the board attorney. Again, I will withhold on any further discussion about what specifically might have occurred in this matter, as that would violate the attorney-client privilege. There is then another section that indicates compliance. This is independent of the disclosure requirement. It says anyone who believes that he or she has information indicating that a board member has a conflict of interest shall make a written disclosure of the facts and circumstances to the board chairperson. And then it says if it involves the board chairperson, the disclosure will be made to the vice chairperson. This provision is not the sole method of raising the issue of a conflict. There's nothing in this compliance section that indicates this is the only method upon which a conflict can be raised. That is all I can say on the issues of what the board policy. I will say one other matter. Board Policy 1320 does provide the chairperson with the obligation to enforce the board policies.
So for due process, to protect not only the individual trustee Daly, as well as to trust the board, it is submitted to the chair. If it's against the chair, it goes to the vice chair in writing, so that confidentiality is maintained and that we can find out if there was a conflict of interest. This is not the first time you have brought things up in a public matter to try to embarrass people.
This isn't about embarrassing you, and you don't need any help.
I didn't say it was about me.
You
Nobody
certainly
has
don't
said
need any
who
help
this
there.
is about.
I had my complaints were delivered to the board, and they were sent via email. They were delivered to you guys before the meeting started today. As far as I fulfill my fiduciary responsibilities, that when I see what I believe to be a breach in the law, to explore that with outside legal counsel and get an opinion from them, and then take action accordingly. You, sir, are, again, as I said, responsible for this.
Thank you very much. Are there any other comments? Yes, Trustee Freeman.
So going back, if I understand this correctly, from what our board attorney stated, that basically, as it's been brought up, that there's a conflict with, or potentially a conflict, even the potential of conflict should have been brought up when motions were made by Sue Couch, that
Excuse
anything
me.
related.
Excuse
So,
me.
no, I mean.
When motions were
it's
made
the
by Sue
question.
Couch.
Yeah, she made a motion to, you know.
Why is she brought up
And
now?
so, because, you know, there's the potential of possible conflict that should be investigated, and before
You're
any.
violating
and before
her due
any,
process
no, I'm
at
not.
this
No,
point.
no, I know, this is.
Sir, you
this
have
is-
violated her
prove
due
it.
process.
Prove it. Prove it. So essentially, what needs to, the potential, like, it should be, hey, you know, I'd like to make this motion, but I might have a perceived conflict, just to let you know, and I probably should stay out of this. That's the basic of it, right? And so we didn't hear anything about that when motions were made. So there's a way of making motions when you actually have a real or perceived, well, actually, if you have a real conflict, you don't make the motion. So we have gotten, you said it's submitted to you, but nothing's been done, and you're moving forward with actions you never completed any investigation or said anything. So essentially, we're supposed to vote on things right now when we have not had any conversation about this. I mean, looks pretty corrupt to me. And so essentially, you're going to drive something through without any thought, care, or consideration about the legality of the action. Then you, sir, have been a massive disappointment as board chair, because that's the first thing that you think about. And the potential for legal liability moving forward. You think that there's no accountability here? If things are done inappropriately, then court is the next level. And I don't think that we want to end up in court, because then a lot of dirty laundry. And we talk about that dark cloud. That dark cloud has gotten even bigger. So if you don't do everything, see, you're trying to do things that you want to do. It doesn't
Please
sound
stay
like you're
on
listening
issue.
to our board
Please stay
attorney.
on issue.
So I'm saying, at the end of the day, everybody here better be very careful that they're doing things by the law.
Okay. Therefore, we have item 2.61, retention of counsel for limited scope employment related to contract
So there was a
offer.
request that John Daly made that Sue Couch not be part of this discussion.
That was actually a point of order.
For what? There has been no individual, no what? We violate somebody's due process? We violate
Well, then you better
ability
stop
to
doing what you're doing and
participate
do the
in a meeting?
due process.
by,
There's no, because it's one more action that you're layering on top of this board that could be illegal, corrupt, and wrong.
could be.
Do your investigation, Andy.
When did you say that to me? Trustee Daly?
Saturday.
You sent me something Saturday in writing to my home.
I sent it to your email address.
It is well known. I don't use email because I don't trust the email system.
That's your problem, not mine. It was a deliverable item.
As you laugh, Mr. Freeman, we well know from this board position what has happened most recently with the emails.
What? Oh, come on, Andy.
However, point of order.
We have a point of order from who?
From Trustee Reyes.
Trustee Reyes.
Whether or not you trust the email system does not mean that he did not fulfill the obligation to submit it in writing.
Okay? So I have my ability to review the complaint and then talk to the trustee involved and then put together my report.
Is it your contention that that has not been done, that you have not spoken with?
I've not received
You have
the-
not spoken
I
with
have not
Trustee Couch
received-
regarding this, nor have you spoken with
Excuse
the
me,
attorney?
How did this person's name, you violated her protection by bantering her name around again. Potential lawsuits,
Yes, there
could
are
be
potential
from
lawsuits.
two people on that end of the table at this point. You
Well,
don't do
there's
that
more
to
than
people.
that. So my question to you then is, so Your contention is that you have not spoken to the trustee in question, nor have you spoken to the attorney regarding this situation?
I have not seen the complaint from trustee Daley
No,
yet.
you were made aware.
Just now.
You were made, no. Otherwise, you would not have had conversation with the board attorney. Otherwise, you would not have known that he was not going to do the contract. Otherwise, you would not have talked to Butzel. Otherwise, the process that you followed was incumbent upon you knowing about the situation. You knew about the situation. You decided to cover it up. And because of that, we find ourselves in the position where we are now.
Your comments are very misleading. I was contacted in September by the interim president. She disclosed it to me, and I approved it because there was no conflict of interest.
So
End of story.
how
that's not the end of
much,
the story.
my question, how much information or how many things are you doing that you don't let the board know about? That you make the judgment call? You're not our attorney,
Please
and it's like
get back to the topic.
we should all be brought in on what's being said, what's being done, and finding stuff at the last minute may have altered the outcomes or conversations that took place. The process should have been disclosure, potential, or actual. But that should all be made known publicly so that everyone has confidence that we're doing the right thing. Right now, I believe that our public is going to look at us and say, you guys hide things, you are not transparent, not disclosing potential conflict is a violation of our Board of Ethics policies. We all signed it. So everyone better think real carefully about where you stand on process and doing things appropriately and transparently. Because at this point in time, if any discussion, any action takes place at this meeting right now that involves someone who has a potential or actual conflict, that calls into question that invalidates the action, and it actually has legal ramifications for people on this board. Whether you can say I did it by mistake or I didn't know any better, but if it comes out that anyone here knew something that they did not disclose, you are legally liable. Remember that. And tell me I'm wrong.
Fear-mongering is amazing how good you're at that.
It's the truth. It's not.
Do you have any conflict of interest as your position on the board, Mr. Freeman?
On this board?
Yes.
No, I've disclosed
Do you
no
have
conflict.
any family members that work at the college? You have routinely
No.
told trustees,
I
as
don't.
well as myself, that you have.
Who? Who's my family member who works
Trustee
at the college?
Reyes?
Who's my family member
Trustee
who works at the
Reyes?
college?
Do
You threw
have
it out there?
a comment or a point of order?
I have a comment. You just indicated that you spoke with the interim president in September about the potential conflict of interest. Did you speak to the board attorney prior to making your determination that it was okay? And what has the board attorney said about this? And if necessary, I will move that we go into closed session to discuss this.
Oh. Under what legal?
Under attorney-client confidentiality, just like you do all the other ones.
There's a problem with that, though.
Okay, you got to answer the question, Andy. You spoke to
I've
Shonda
got to
in
answer
September.
the question?
Yes. You have an
13
obligation to address
Let's go back to what I
you
told
have-
you already. Conflict of interest, item 7. I did it. That's
I'd
what
like to
it
hear from
says
the board
do.
attorney on
I
this.
saw no conflict of interest.
Because it fit your narrative. I'd like to hear from the board attorney regarding this.
You'd like to? Please ask the question.
Is there a conflict of interest in the legal opinion of our board attorney?
Is there a conflict of interest in the legal opinion of our attorney?
Yes.
I have done no investigation to that matter. There has been no complaint
So if there's no
filed to
investigation,
me
how did you
as to
clear it?
relating whether he has a conflict of interest on anything. If you would so like to send that to me, I will review it.
Andy, you're playing games here.
You're the one that asked the question.
I'm
I just
asking the
answered.
board attorney.
Question asked, question answered.
You just indicated you had no investigation before ruling, that it was
You
fine,
asked
and
me
I
if the
asked
board attorney
of
had
the
a
board
conflict of
attorney.
interest, sir.
No, I asked of the board attorney, not that the board attorney, of the board attorney. Is there a conflict of interest in this situation?
There's
That
no
was my
conflict of
question.
interest. There is no conflict of interest.
I challenge you on that.
I challenge you on that as well.
Fine.
Excuse me, Mr. Chair. We have a point of order that John Daly indicated that the matter should not go forward with trustee Couch voting. I believe you ruled on it and said that his point of order was out of order. Then trustee Friedman made it as a point of information for a legal inquiry of the board attorney, and then this discussion has ensued. So I don't know if there's another point of order, or if you are going forward with, based on the ruling that you made earlier.
I appeal
So
the,
maybe I
I
perhaps,
appeal the chair's
so there's-
decision
okay, so that puts it,
on my point of order.
okay.
So there's been an appeal of the board attorneys, or the chair's position. Is there a second to that?
That's not required.
Okay. Since you've challenged, we now have a vote. Diane, I will ask that you would help explain how this, if it's a yes vote, the chair is correct.
The
Please
appeal,
explain.
you ruled that trustee Daly's point of order was out of order, and therefore, trustee Couch will be able to vote today, and you made that ruling, so he appealed the ruling, so a vote of yes would sustain your ruling, a vote of no would sustain what trustee Daly raised in his point of order.
So a yes vote, and trustee Couch would be able to vote. And a no vote, she would not. And we would agree with trustee Daly, correct?
Yes.
Okay, so a yes vote, you agree with me, and everybody continues to get to vote. Roll call vote. Trustee Reyes.
No.
Trustee Freeman.
No.
Trustee Couch.
Yes.
Trustee Daly.
No.
Trustee Walcott.
Yes.
Trustee Swanson.
Yes.
And I vote yes. Passed. Item 2.61, retention of counsel.
Point of information. Point of information.
Point of information.
Why do we need a separate attorney for negotiation of an employment agreement when we have a board attorney?
Because the board attorney contacted me, as I just read to you at the beginning of this. He has refused to serve as counsel for the contract. He does not want to do it. And he's also informed me that he will be leaving.
On what basis does the board attorney not want to fulfill his obligation to negotiate this contract?
He has a concern. That's his concern. The
concern
law
should
firm-
come to the board.
The law firm that I discussed is the same law firm that you wanted as the board attorney.
That makes no difference.
It does.
No, it doesn't.
You want a quality law
No,
firm.
because if we were to go through another procurement process, they may or may not be the firm that I voted for. So if we're going to change attorneys, then we need to go through the procurement process in order to do so, and that involves the whole board. Not just you having conversation
We are
with...
able to
with
move forward
a-
and.
Point of order.
Freeman did this in the past when he was chair.
No, come on. Games. I'm calling games on this one.
When
It
Mr.
really is.
Delaney
This
was
is
not the
violating,
attorney,
this is
you
violating
discussed
procurement. This is
with
violating
the law
procurement.
firm
Procurement,
that you brought
procurement,
in.
procurement. You're violating procurement. You just pick somebody, you know, like we go through a process. We do things transparently. This is not transparent. So at this point in time, if you vote for this, it's very obvious that there is an agenda here, and you're just pushing something through that doesn't have to be done right now. Because you're rushing a process to try and like glaze over. Guess what? When you look back in history and what you did, everyone's gonna look at you and say you were part of it. You did something illegal, and I myself will always walk away from this board saying I did everything ethically and appropriately. So at this point in time, there is no reason to do this right now, and I want the investigation completed that you say that you're going to do, but probably not going to do anything, and actually with the exit of our board attorney, that you're just, you know, you just want the vote. You want the 4. And so at this point in time, remember, when it comes down to it and everything comes out, if we are in court, everything's going to come out and there's no burying any of this.
Thank you very much, Mr. Freeman, for your fear-mongering again.
Point of order.
Yes?
My point of order is that in unilaterally soliciting a bid, a proposal, and from what I read in the letter, apparently accepting the proposal, you grossly exceeded your authority as the board chair. And I recommend you that to me suggests a conflict of interest, and I recommend you step down from the chairmanship immediately.
Well, I rule that you're incorrect, because if you read the document, if you had taken the time to read the document, you would clear, I didn't approve anything.
You went out for a proposal. You solicited a proposal.
I have the ability to do that under Board Policy 1320, proper pertaining to the office.
I appeal.
You appeal. The ruling of the chair has been appealed. If you vote yes, the chair is correct that I did not exceed my authority. If you vote no, you agree with Mr. Daly that I have exceeded my authority and had no right to contact the law firm to get them involved so that we would have them to work with. So no, you're agreeing with Trustee Daly. Yes, you're agreeing with me. Roll call vote. Art Reyes.
No.
Freeman.
No.
Couch.
Yes.
Daly.
No.
Walcott.
Yes.
Swanson.
Let me first say that you're right, this whole meeting is not very enjoyable, not very nice, to say it politely. I personally didn't think Andy overstepped his bounds. He got a free consultation to bring us a proposal. It's extraordinary circumstance. It's up to us whether we accept it or not. So with that, I'm going to vote with the chair.
Is that a vote yes?
Yes.
And I vote yes. Your appeal fails.
Mr. Chair, may I mention that there actually isn't a motion on the floor?
Yes, that's what I was going back to. 2.61. Retention of counsel for limited scope employment rated into contract offer to President Shonda Richardson Snell.
Mr. Chair,
Yes.
I move that this motion be tabled until the next regular scheduled meeting of this board.
Second.
We have a motion and second, and that would be to stop this? What's that?
I said no. That's not
It would be to
correct.
stop it at this meeting.
This would simply table it and postpone it to a further meeting.
Okay. Is there discussion on this? Is
Yeah.
there any discussion? Trustee Swanson?
If we retain Butzel and Long, will they be able to give us a legal opinion on the issue at hand, on whether the conflict of interest is a conflict of interest or if it's nothing? Will they be able to give us that answer, being as they're a higher education, they specialize in that, correct?
Yes. Trustee Freeman?
So that issue is not part of this motion, number one. Number two, I believe we do have an attorney here right now. I mean, is there an emergency? Like, do we not have an attorney? I've not been notified of any, like, time frame. Is it today the last day? Is there so, maybe if Mr. Brickley is not here, is there someone else there's a lot we don't know. So essentially, why is this an emergency right now that we get somebody in here to negotiate a contract where we still, he won't do it, but, I want to make a public apology too, to Mr. Brickley. I've been really rough on him. And I've got a lot of post-traumatic stress disorder from certain individuals on this board. But I've found him to be of the highest ethical character, that he has represented us well. And for one, I should not have been so rough on him. He is a good man, and I believe in his character. And I think everyone should listen to his counsel because he is an attorney. And I'm done listening to Andy with his legal interpretations and policy interpretations. So I thank you very much.
Mr. Chair?
Yes, Trustee Daly?
Thank you. We have an opinion that I believe we will be discussing at the 5:30 meeting, which is on point with this. You're doing the equivalent of judge shopping, where you're shopping around to find a legal counsel that will give you the answer you want. That's unethical, sir. And it does not behoove you.
That's Fairmont Green once again.
Mr. Chair?
Yes.
Trustee Freeman this is the first nice things that he said about Mr. Brickley. Normally, it's that he's not a higher education attorney, that he shouldn't be here. We hear it from the audience. Most meetings we hear that. All I'm asking is that, we were lambasted for not hiring when Butzel Long was in the running, that we voted for Mr. Brickley. I'm not saying he's right or he's wrong. I'm saying that I would like just a second opinion. And if we can retain Butzel Long and they can give us their opinion, then that would go a long ways into what I would be willing to do in my outlook on this.
If we retain them between now and 5:30 meeting, we should be able to get an opinion. Trustee Reyes.
I think Trustee Swanson has made a very good point as to why this issue needs to be tabled.
And I know, Mr. Chair, you want us to follow a legally correct process.
I'm sorry?
Mr. Chair, I know you want us to follow a legally correct process in doing this and making sure that we do have a correct answer. So I believe that asking for a legal opinion on a matter that's this complex by my calculations, 5.5 hours notice is really inappropriate.
Mr. Chair,
Yes.
I understand what you're saying, John. We need a second opinion on this. It's very important. I'm sorry, John. If we retain this law firm, I'm not saying we have to have the decision in 4 hours, 5 hours. I think we should retain them to give them the chance to look into this, and not to table this, but to look into this to get a separate opinion.
Okay.
They very well may side with Mr. Brickley. They may not. Who knows? But we won't know unless we get their opinion.
A question.
So what needs to happen is if you table this now, we don't have Butzel to do any research for us. So you need to have the attorney.
Point
to
of
go
order,
through
that's
with the
not
motion
the,
to
that's
get the
not the
attorney.
resolution.
That's not the
That's not the
And then
resolution. The resolution is
Find out for the
written.
next meeting. You were the next person to be called upon, Wendy.
Is this a temporary retainment or permanent?
No, this is just temporary.
First of all, you're introducing something that's new, another motion onto the agenda is restricted to those items specifically on here. Seeking a legal opinion for a conflict of interest is not one of the things that's on there. The motion that's on the table for us to look at, to address, is selection of this firm for a specific purpose. What you're suggesting is different than that. It
Thank you
does
very
not meet
much.
the criteria that's on the table,
Thank you very much.
and you cannot change it as a special meeting, as
Are
you're
there any other
aware.
comments? Trustee Reyes.
Yeah, 2.61 is retention of counsel for limited scope employment related to contract offer to interim president Shonda Richardson Snow. There's nothing in there that says asking their legal opinion on a conflict of interest. However, a separate motion could be put so that Jeff would be satisfied. We could make a substitute motion that they be asked specifically for the conflict of interest, in which case we wouldn't have to vote on. We could table whether to retain them for the contract negotiations.
Mr. Chair?
So, yes, Trustee Daly.
I would just read the response letter from Butzel to us, and take in mind what's on paper counts. Okay? Dear Mr. Everman, I am pleased to confirm your engagement of our firm to provide legal services to Mott Community College. You have, past tense, engaged us to provide advice and services in connection with negotiations and drafting of an employment agreement for the new president of Mott Community College. That's all past tense. That has happened. This says engaged. You intentionally entered into discussion with them without the board's authority, and you engaged them. Okay, you grossly overstepped your bounds again, and again, I file a. You should step down from this.
Thank you very much. Are there any other comments?
I don't know what you.
Trustee Freeman.
Yeah, I would like to ask our board attorney if he agrees with John Daly's assessment that the thing is now it's been publicly reported that we're kind of all deciding to do something together, but it appears that with that letter, you basically have hired somebody and now you're asking our blessing after the fact.
You know, I can't comment on the meaning of the terms that Butts Along uses. It looks like a form engagement letter that they send out with form attachments. What they specifically meant by that phrase, I don't know, you'd have to ask them. I mean, in a general sense, yes, engagement could be, yes, we've been hired, but they may have a different meaning of it, and it could be simply a response to an inquiry. I can't answer that for you.
But it could be perceived that it's been done.
Yes, it could be, yes.
Thank you.
Trustee Daly? Any other comments? Okay. So what we have on the table at this time is to table item 2.61. If you table that, a yes vote would table that, is that correct?
The motion before the board, made by trustee Daly, is a motion to table to next
Point of
meeting.
order.
That's actually to postpone to a time certain, which is the next meeting. It's not to table, it's not to get rid of it, it's just to move it to the next meeting. That's my understanding of his motion.
No, my motion was to table.
Robert's rules would say table gets rid of it completely. Is that what you want to do? Because you said to next meeting.
I'd have to,
You said to next meeting. Is that your intention to have it put on the next meeting?
okay, postpone, I'll buy that.
Okay. So a vote yes would put it to the next meeting, correct? A vote no would allow us to go forward with this and then to engage Butzel, and then we could move forward with the next motion.
It'd only be to, go forward with the motion, not to engage Butzel. You would not be engaging Butzel by voting no.
We're talking right now about his motion.
Right.
But I'm explaining what ultimately happens.
Right.
If we put this a no, we do not have their law firm looking into this matter between now and the next meeting. So a vote yes tables, would table.
Postpones.
And a vote postpone.
A
And
vote no would
yes
simply mean
a vote no would move forward.
you address it today, yes.
A vote yes would postpone, and a vote no would move forward.
Mr. Chair, I do have one more question of our legal attorney. If it is determined that there is in fact a conflict of interest by one of the people voting on this matter, what is the implication for that? Does that mean that it invalidates the action?
So I believe I provided a detailed legal memorandum on that issue. I don't think at this point in time it would be appropriate for me, because I think it might border on violating the attorney-client privilege to give a more specific answer at this time. As a general rule, some of the discussion here is most likely accurate, but I'll leave it at that.
Thank you.
A vote yes is to postpone. A vote no is to move forward with the motion. Roll call vote. Trustee Reyes.
Yes to postpone.
Trustee Freeman.
Yes.
Trustee Couch.
No.
Trustee Daly.
Yes to postpone.
Trustee Walcott.
No.
Trustee Swanson.
No.
And I vote no. 4 votes no. We are not postponing item 2.61. We are moving forward with item 2.61. Do we have a motion for item 2.61?
Mr. Chair,
Yes.
I move that we retain the firm of Butts Long pursuant to their proposed engagement letter.
Okay. Do we have a second?
Second.
Do we have a second? Discussion. Mr. Reyes?
What is the timetable for the negotiations?
We don't know till we enter into it and start talking with her.
You've already started talking with her. I'm asking what the timetable is for this board, because we are in the month of December, and we have a lot of things coming up because of the holidays, and I want to know if we're going to be called into more special meetings in order for negotiations.
I would say you're going to be called into more special meetings in December. Trustee Freeman?
Yeah, just a comment on this and what's been discussed. I'm going to reinforce the fact that I think this is a really bad idea. I don't understand why this has to be done right now. We do have legal representation right now. It's a separate issue that you bring up about looking at the conflict of interest. If you want a second opinion on it, that's fine. Although you're right, the outcome may not change, might be the same. So you vote on this today, second firm says, hey, there was a conflict, and what you just did was you engaged somebody that you were not able to engage. So, and then it's going to be more back and forth and more fighting and more public humiliation. I just think that this needs to stop right now, and everyone should probably take a breath and really figure out carefully what your next steps are going to be. Because I know what mine are.
Thank you very much. Any other comments?
No discussion.
Yes.
You asked. There's no discussion.
Any other discussion?
No.
Okay. All right. So we have a motion on the floor to retain of counsel for the
Mr.
limits.
Chair.
Trustee Wendy.
What's that? I have a question.
Yes.
As part of our retention, will it include legal services and advice in connection with the matters that arise? This includes legal objections, legal challenges, and other legal issues that come up prior to the execution of the contract?
So as soon as we get done with this motion, if you want to bring that motion up, that we do that, we can, because that is
Sir,
what
that's not on the
trustee-
agenda.
that
It's
is
not on
what
the
trustee
agenda.
Swanson had asked
Not
if
on
we
the
could
agenda,
do.
Andy. Andy, not on the agenda.
So, excuse me, I'm
It's
speaking
not on
to
the agenda. I'm
trustee
just
right
letting.
now.
Point of order?
Being helpful.
Point of order. Well,
My point of order is that what you're suggesting is not on the agenda, it's not allowable at a special meeting.
okay. Do you have any comments, further comments? Do you have any further comments?
I said, my God, you're speaking.
Wendy, you had your light still on. Okay. So at this point, retention of counsel for the limited scope employment related to contract offered to interim president Shonda Richardson Snell. Roll call vote. Trustee Reyes.
No.
Trustee Freeman.
No.
Trustee Couch.
Yes.
Trustee Daly.
I decline to vote because I don't want to participate in what I perceive to be an illegal activity.
I'm sorry? There's a requirement that we vote. Bill, could you cite the policy for him? Please cite the reason why you're not voting. I'm sorry, please use your microphone.
I told you.
Okay. Diane, do you have that?
I believe that's a legal question for what attorney about
He had a.
his
he's
ability
not
to
voting.
abstain?
And Bill, do you have that?
I don't have that. There's nothing in your bylaws and policies. I'd have to review the Michigan Community College Act and give you that decision. I suspect for the time being, it could be noted as abstaining.
We have no policy on the requirement to vote. I believe you will find it in there.
There is actually a policy on abstention. It's, you can only abstain due to conflict of interest. I don't know if we specify, though, whether it's a personal conflict or just a general conflict of interest, but I'd go with the latter.
Give me a minute, I'll find it here. I've got the act here.
Mr. Chair, I'll just remind everybody, I do know about this because of the number of times that you tried to abstain, and it was for reasons other than conflict of interest.
Mr. Chair,
Trustee Reyes.
I don't want to miss any votes, but I have to use the restroom.
I'll tell you what. I will make sure that we'll finish this one up even if you're not here, but we won't do anything else till you get back. There's not going to be another vote till you return. What's that?
I'm going to wait for him to get back.
Did you find it?
I found the provision.
Okay, we have an opinion from the attorney.
MCL 389.113, Section 113 of the Michigan Community College Act addresses the situation of quorum, voting required, conducting business at public meetings, record keeping, availability of record to a public, duties of the chairperson, secretary, and treasurer. Although the title itself indicates, quote, vote required, end quote, the specific language of the statute does not indicate any type of requirement of an actual vote. It simply says the majority of the Board of Trustees is a quorum, but an act is not valid unless voted on at the meeting by a majority vote of the members elect of the board and proper record is made of the vote. Again, there is nothing in that statute requiring any person to actually record a vote. And again, given the short notice of this request, that's about the best I'm going to be able to do at this time.
Michael? Michael? That's not the way you went. I remember.
Just
We always had to vote.
one more
I'm
item.
sorry?
One more item. 1660. Okay. Yeah, here now under 1660 of your vote, it says voting method of your policies, the board shall take any action by way of motions, blah, blah, blah. And then down at the bottom it says obligation to vote. Each member present is obligated to vote upon all matters submitted for action unless there is a legal reason to abstain, such as conflict of interest. And so that is in your policy.
So I was right, Andy.
Oh, I agreed with you. I just didn't know the policy. We've gone through this many
Well,
times before.
Yeah, I know, and I know, and so, but I would also defend Trustee Daly's right to abstain because of the legal nature and conflict. It doesn't say his necessarily. I mean, he has identified what he perceives as a legal issue, and I support his right to abstain.
Trustee Daly, your vote? Okay. Trustee Walcott?
Can you repeat the motion, please?
Okay.
The motion is to retain counsel for a limited scope employment related to contract offer to interim president Shonda Richardson Snell pursuant to the engagement letter that was received.
Yes.
Trustee Swanson?
Yes.
And Trustee Overman is a yes. We will retain them. The motion is passed. In order to put to rest the issue of my authority to have participated in this free consultation, I would entertain a motion to ratify my ability to talk to them in a free consultation.
This is ex post facto.
So moved.
Is there a second?
Second.
I have a second. Any discussion? Roll call vote. Trustee Reyes?
No.
Trustee Freeman?
Oh, no.
Trustee Couch?
Yes.
Trustee Daly?
Never.
Trustee Walcott?
Yes.
Trustee Swanson?
Yes.
And Trustee Overman's yes. That passed.
Chair Everman. Chair Everman.
Point of order? Point of order?
I know that Trustee Daly said never, but as you may recall from a previous meeting that we had, it was...
Yes or no?
Yes or no, just
Okay.
to be
Trustee
clear.
Daly, would you like to fix that?
What do you mean, fix it?
You said never. It's either aye or yay, yes or no.
Two things. First of all, you've added something.
Discussion has stopped.
I'm not, point of order. This is a
Discussion
point of
has
order.
stopped.
This is a point of order. You are obligated to listen to what I have to say. I know you don't want to hear it, but you are obligated to listen to what I have to say.
Please state your concern.
I'm trying to. Do I have the floor?
Yes, you have the floor.
You just added a third amendment, another item to the agenda, and it can't be added to the agenda at a special meeting unless it's approved by all members.
Yes, the board can approve my action after the fact.
You
It's
can't
a
add it
motion
to the meeting at
ratify.
a special agenda.
It's a motion to ratify my actions.
No motions are to be added to the agenda at a special meeting unless the board approves it unanimously.
It requires 4 votes to pass, and yes, it is.
It's not what the bylaws say. You need to check the section under special meetings.
You need to check Robert's Rules of Order.
Special meetings, our
Robert's
bylaws
Rules of
will take
Order.
precedence.
Diane?
Point of order has been made. You've ruled that the motion was in order.
So your vote, Trustee Daly?
Never.
That doesn't work. It's either a yes or no.
Never.
Okay. Bill, what do we do with this?
It is the chairperson's role to enforce the bylaws or policies. It is not mine.
Okay. So, Jordan, how would you suggest, because we don't know what he's doing?
I can't make a determination on that. I just wanted to make you
cannot.
aware of the past meeting that had been called for special meeting because there was a board member who was not clear in their vote on a motion, so that's why a special meeting had to be called again to clarify that action.
Okay. So we have 4 votes.
We have 4 votes, but for purposes of the minute taking, Trustee Daly, may I record in the minutes that you have voted nay?
No.
So we've got a no.
Point of
from you.
order.
Thank you very much.
Point of order.
Passed.
You still have not ruled on my fact that this was an illegal activity based on our own bylaws.
I just explained it to you.
Then I appeal the ruling of the chair.
Okay.
Our bylaws are very specific. Break it open and read it. Are you afraid of this or what? Very simply stated.
It's a motion to ratify a deemed authorization. It is treated, and we have made a motion, it has been seconded, and we voted.
Bylaws say that you can't add to the agenda of a special meeting.
As this relates to the item that's on the agenda.
No,
You
that has-
cannot add, no.
It's completely different.
You wouldn't have required a second motion. You wouldn't, you took it as, you chose to take it as a second action, separate from the original action.
Correct, it's not on the agenda. We've just violated our policies.
The policies provide in 1530, special meetings is business. No business shall be transacted except for that which a special meeting is called, unless all members are present and concur in the addition of other items to the agenda. The two items on the agenda were retention of counsel for limited scope employment and the authorization for the interim president to sign the required documents for the put-call agreement. Those are the only two items that were on the agenda, so unless you have consent of all, it would appear as if any other items should not be discussed or voted on at this meeting.
Okay.
So Trustee Daly is correct.
Again, there was a point of order made, the chair made a ruling, and I heard an appeal. So the discussion's appropriate on the appeal. However, that's what's on the floor is the appeal.
So so to end this appeal, where I am wrong on this one. So there is no reason for an appeal. This motion needs to be removed from the minutes.
No, it's on the floor for a vote.
Mr. Daly, I am speaking. Mr. Daly, please wait a moment.
You're not going to escape.
As I understand it, from having the board attorney read it, it cannot be added. I understand that now. You appealed it, challenged the vote, mooting of the chair. It can't be done. So the point is moot. There is no motion. Can't go forward.
Mr. Chair, are you changing your ruling?
You've already.
He's changing his ruling.
So I
want to vote.
Ruling's
I'm
changed.
entitled to a vote. On my motion, on my appeal, I am,
What are you appealing?
Once it's there, you can't withdraw it. It's up for a vote, and the board is the one that decides whether it stays or goes.
Bill, is that accurate? I can't change my mind.
You can change your mind.
There you go, John.
You're welcome.
Since there is nothing further that I see to come before the meeting today from our agenda, this meeting is adjourned.